Good afternoon, everybody. Hello, and welcome to this afternoon's webinar. I suppose the title on the webinar that we had on the webinar invite was a little bit to the different to the to the content. So today, actually, the earlier webinar was all about grievances and complaints within the workplace, and this particular webinar is all about, as the content said, how to hold a disciplinary. So really, how to deal with workplace issues. My name's Amanda Chadwick. I'm a senior speaker at Peninsula Business Services Limited. We're a family-run firm based in the Northwest. I'm based in North Wales. We have offices in Belfast, Dublin, Jersey, Glasgow and Sydney. If after this webinar you aren't a Peninsula client and would like more information, please email me, amanda@peninsula-uk.com. However, if you are a Peninsula client, remember you pay us your monthly fee to advise you and write the letters that you would need for any workplace issues. And your policies and procedures, we know what we've written, so we can take you through every step of the way. So disciplinaries. Well, the first thing is to remember that you have to establish disciplinary rules in the first place. ACAS code says that you have to have disciplinary rules, procedures in place, written down within your handbook. And disciplinary rules are necessary in any organisation, regardless of size, to establish the expected standards of behaviour and performance of your employees. And such rules enable you, the employer, to run the business effectively and provide guidance on the company's expectations of the performance of its employees at work. So what I'm looking for is clear and consistent disciplinary rules that are provided in writing to the employee, preferably on induction, in the form of a company handbook, as well as stating the rules on what conduct is acceptable. So every business is different here. What might be one rule in one might not be in another. So, for example, mobile phones, you might ban mobile phones if you work for the MOD or the military or in a nursery, for example. But if I was in a marketing office, you might not. So what conduct is acceptable and unacceptable is different within which workplace. The rule should contain the consequences for employees should they not attain these standards. And your rule should make it clear that if an employee fails to meet the minimum standards of conduct, you may begin disciplinary action against them, and also should give examples of the type of behaviour which wouldn't be tolerated and which could be considered gross misconduct. So that's conduct that's so serious it would lead to dismissal. So, it is a last resort. So what I want to do at the end of the day is to avoid an employment tribunal. And you'll know yourself when people get it wrong at tribunal, it's basically because they haven't got the right policies, procedures in place, haven't followed the right route and made up rules that they've gone along. So what you've got to consider, the cost of getting it wrong, we need to get it right, is the time and expense in preparing for a tribunal, the time and expense in attending one. It's very stressful, the bad publicity. If you get a case that's quite colourful, it will be in the local paper and the big papers will pick up it, especially the Daily Mail. They love it. Poor reputation as an employer, legal costs even when winning. Spoke about this morning. The other day, I was at a seminar at Sandown Racecourse. A lady there, she's only got a gardening company, so not a major, corporate organisation, but she does well for herself. Has a problem with an employee, she decides to fight it. She ends up, she says, winning. Her legal fees alone were 40 grand. That's a life-changing amount of money. So legal costs even when winning, wastage management time, reporting to other statutory bodies. But what I want to do is stop that happening in the first place by being preventative, excuse me, and getting things in place that will help you. So I'm going to try, what I'm going to do, there's 82 rights the minute I walk through your door as an employee. I'm going to establish rules straight away through the form of policies and procedures to make sure that I get employers' rights. So I'm going to put standards and expectations in place in the form of a handbook. I'm going to put a job description in place. So if you're not performing properly, you're not doing the job you should be doing, I can say to you, that's your job description. That forms part of the contract. You're not performing like you should, and maybe go down the capability route with that person. I'm gonna, the only person that actually gets a contract, by the way, is either an actor or a footballer. Contracts are everything. It's what you say at the interview, it's what you have on the job description, it's what the statement of main terms is, and it's also the handbook as well. It all forms part of the contract. So, okay, let's establish these employers' rights and let's get handbooks in place. And just to confirm to you, the first mistake that an employer makes, and this is prior to a tribunal, they don't issue contracts, okay? They don't issue them. They don't issue rules, don't issue contracts. What happens is they end up in a tribunal thinking that the tribunal will look at them because they're a good employer, but legally they then find out they should have issued statement of main terms within 8 weeks. I'd issue them from day one. It should be within 8 weeks. Penalty for not issuing in tribunal on top of the other compensation awards. And, later on in employment, if you're going to change it because of, changing hours or they're changing to go into part-time, there is a process for doing that. And you need different contracts for different types of staff because your workforce is different. So you might have temporary workers, full-time, part-time, etc., etc. And more than ever now, you've got to check your workforce status because of pension auto-enrollment. So where other employers make mistakes is not having written standards and expectations. So rather than saying this is our rule on uniforms, it's written down. They say, yeah, we've got a uniform rule. And I say, where is it? They say, well, they just know what they've got to wear. That's not good enough. Although it's custom and practice, it works well for the employee. But it doesn't work well for the employer because there's no rules written down. So when you say I'm disciplining them because they're not wearing the uniform, they'll just say, where's the rule? So your staff aren't mind readers. So what you've got to do is formalize what already exists because people are scared of doing that. And also a lot of people don't realize there's a legal requirement for certain rules and procedures. My webinar this morning on harassment, bullying, grievances and complaints, that just established the fact that you've got to have an equal opportunity policy in place, harassment, bullying policy, investigation, disciplinary appeal, grievance procedures all in place to make your life easier. And so there's no surprises later on. This is the rules. Follow them. What you want the job with me. These are my rules. Okay. This is how you ring in sick. This is how you do this, how you do that. Okay. And you've got to make sure that you show all this to somebody on day one through an induction, training your staff, education of staff, and making your managers and supervisors aware of what their roles are and maybe putting it in their job description, because you as the employer, and if you're an HR listening to me, you have vicarious liability. Basically you get the blame if it goes wrong. Being scared of changing what isn't broken, I don't want to put a rule in place because people might be offended. It's going to make your life easier. It's going to make that, that's when you go into a disciplinary, it's going to make it easier to prove that you did the right thing. Don't copy somebody else's policies and procedures because you're copying somebody else's rules. Make them applicable to you. Don't get emotional. Somebody says, I shove your job, I'm not working for you anymore, and you feel like going, yeah, well, I don't like you anyway. Really, you've got there's a procedure to follow, and a lot of people forget that. You've got to let them go, write to them to give them a cooling off period, reflection on what they've done, and then bring them back in for a meeting. What you're not going to do is send a P45 in the post because you've got no defence then. So emotion takes over. Consistency. Don't make rules up as you go along and choose who the rule applies to. Be consistent with every decision that you make. So you've got to issue job descriptions, because if we're going to go down a route of disciplinary because somebody's not performing, if we're going down a capability issue, we need to have proof that we've got job descriptions in place, and we do KPIs, and that we've got a benchmark, and that we do appraisals as well, and that everybody is aware of their duties. So it's proof again for us defending our clients. If you get the wrong person for the job and you're trying to dismiss them, it's because basically I think sometimes that your personal specification wasn't written properly, and you might not write them, for the adverts that you. And if you do get the wrong person, there's always a way out. There's a suitability clause you can have within the probationary period, and also a little section that says short service staff will make it a little bit quicker to get rid of you. I am giving you an overview in law here today, but I'm just giving you an idea of the nuggets that you can have within policies and procedures to give you more control. Not creating a paper trail. People go through a disciplinary and don't write letters, don't communicate, and then what happens at tribunal? That's what they depend on as defence. If you haven't got a paper trail, then you're going to be guilty. People don't understand the ACAS code of practice or why it's there. They just guess it, and guessing it is going to get you in trouble at tribunal. And it's horrible to think that you've done everything right, but just because you've missed a letter out, just because you've not done the process, what's going to happen is that person that really should have been dismissed is going to win their tribunal. Remembering those written rules for investigation, disciplinary, grievance and appeal. Making one mistake is going to mess the whole thing up. Employers may not take complaints seriously. make sure you've got capability policies in and keep up to date with employment law changes. So what are the policies that are going to help you with disciplinaries? Okay, this is the first page of just one, okay? And this is just a scraping of the surface. There's lots more that are applicable to you. But these policies help you because if somebody isn't abiding by your rules, i.e. you've got a sickness reporting procedure in place and they're off sick, but they haven't rang in within an hour of the shift start and they haven't sent a note in, then that's a conduct issue, actually. That's a conduct issue. You're going to talk about the conduct, okay? And you can take them down the conduct route, not because they're sick, but because they didn't follow your rules. And these all go in your handbook. How they claim expenses, if they manipulate the expense system, cash handling, if the till's down, etc. Health and safety policy, not following health and safety rules. It might be an alcohol policy, holidays, how they request it. You know, there's lots of policies that you can use that will work for you to run your business and make your business life a little bit easier, but at the same time make it easier when it comes to a disciplinary. So rights to search. You know, you might want to search somebody, you might use that for tendering, they might steal, they might drink alcohol, take drugs, and you might use a mobile phone. You might never have heard of a search policy before, but it is actually harder to prove that somebody's stealing and taking drugs and alcohol than it is to prove they refuse to search. So a search policy saying refusal of you to agree to being searched will constitute a breach in your contract. And then in under gross misconduct, put refusal of a search. You can see how they all link together. Notice period, internet and the usage of relationships at work. I'm not bothered if you have a boyfriend or same-sex relationship, have an affair or get married to somebody at work, but the minute that you fall out, it causes an issue for me as an employer, or you're off meeting people when you should actually be working, then I could talk to you about the relationships at work, and it's part of my policies. Again, not wearing the right health and safety gear or dress code, smoking, absence reporting. You know, these are all about control and making your life easier when it comes to investigations and talking to your staff. So the common mistakes people make with disciplinary grievance and dismissal is that they don't let people have the right to be accompanied. They refuse them the right. Imagine a small garage in Wrexham where I live, and they go through a disciplinary without letting them have somebody there. They don't establish the facts. They just take everything on face value. They just listen to their fellow colleagues and they're guilty straight away. So people don't understand the ACAS code, the right to be accompanied and whereabouts they should. They don't establish the facts. They don't get the right information on the problem. They don't take the appropriate action. Either it's too severe or too lenient on other people. And they pick and choose how severe it would be. They don't give people the right to appeal and suspension without prejudice. So you've got to think about those, because that's where lots of employers get it wrong. Things to remember: emotion there again, remain in control, remain calm no matter how angry you are. Don't over talk in an investigation or disciplinary. Listen to what they've got to say. Be consistent. They could be innocent, but don't think that they're guilty straight away. Remain neutral with this. Investigate thoroughly, and don't just say you're going to investigate. Really investigate it thoroughly, okay? And they're not mind readers. So the foundations that you should have in place a disciplinary policy and procedure that is in line with the ACAS code of practice. Make sure this disciplinary policy and procedure includes examples of misconduct. You know, I've given you some examples there, and it's generally not abiding by the health and safety rules and procedures. Smoking in designated non-smoking areas. They might be rude towards your clients, service users or colleagues. They might have persistent absenteeism or lateness, unsatisfactory standards or output of work. And each rule is really, and failure to adhere to a stated policy and procedure, that's just an idea of misconduct. And as I said, the severity of it is whether you have to consider that. So why take disciplinary action in the first place? Either a rule has been broken or an offence has been committed. And if you've recognised following a thorough investigation, then what action should you take? Okay, so do you go down the formal route or are you going down the informal route? So the outcome will really depend on the severity of what the misconduct is. For minor offences, you might not have to go through the full formal disciplinary procedure. Informal action can be taken that may consist of a discussion about the minor infringements. It might be lateness, for example, and after talking to them, after investigation, and they've explained to you they've got problems with roadworks, etc., you might consider it a minor infringement. It might just be a letter of concern. It might be a letter of concern about sickness, for example. It doesn't always have to go down the full formal disciplinary procedure. A letter of concern might just do the business. It might just highlight the problem, that previous discussions that you've had with them about lateness maybe or sickness, they've taken place, and that they've continued to fail to adhere to the rules. And what you're going to do is just re-emphasize that. And once somebody gets a letter, sometimes it's just the kick up the bottom that somebody needs to remind them that if it continues, they're going to go and it will result in disciplinary action. And in the event that the offence is more serious, then you are going to go down the formal disciplinary action may be necessary. And this is what you're going to do. The key components of formal action do consist of an investigation, disciplinary, and then an appeal. And the investigation is very important because you're gathering facts here regarding the broken rule or the committed offence. You need to assess it based on those facts alone, whether this is a case to answer. Then what you're going to do, and it might be that you suspend somebody during the investigation because you need to suspend them on full pay. It might be a disciplinary, so you then go to disciplinary, and this is where you're inviting the employee to a hearing to discuss allegations and enabling the employee to state their case, applying a suitable sanction where necessary. And then when you've made that decision, you're going to write to them, inform them, and then you have the right to appeal. You need to put that in the letter. And this is where an employee can state their disagreement with the disciplinary outcome by stating their reasons or introducing additional information in their defence. So the purpose of a disciplinary action, it really is to resolve problem situations constructively, not to catch employees out by springing surprise allegations on them on top of what you're supposed to be discussing. You're there to listen to mitigation and sort of remedy it so we don't have this issue again and it's all sorted. But why should you follow the procedures? Those procedures are put in place, and they came in place in 2004. They were put in place to apply consistent and fair within the workplace. And if you're not doing so, the employee may decide to take their case to an employment tribunal. And there are 3 tests for success in an employment tribunal. Was the reason for dismissal a potentially fair one? Was a fair, equitable and reasonable procedure followed? So that's your own procedures. And has the employer acted reasonably in the circumstances? So there's 5 reasons why we can dismiss somebody. Conduct. Remember that sickness thing that I said? We're not talking to you about your sickness. We're talking to you about why you didn't ring in with an hour of shift starting. A capability issue. Are they capable of doing the job? Have you looked at reasonable adjustments? Is it a disability? And again, that's why it's so important to have that policy within your handbook. Redundancy. And I really want to speak to you before you think about making redundancies, because I can implement so much more within your businesses before you make that redundancy where you might save a bit of money. Statutory ban. And it's not as clear as you think, you know, a statutory ban, like losing their license, lose your job. Not necessarily. You know, how long are they going to leave? You've got to look at each case on merit. How long are they going to lose their license for? Is it worth re-recruiting if it's only a 3-month ban, for example? And could you move them to another job whilst the ban is on? And then some other substantial reason, which is what a lot of people do use. So when we look at the test, we've got to look out whether the investigation disciplinary was carried out in a fair manner. Have you followed your own contractual procedures? And you're tempted, aren't you, when you know somebody who works in HR or is a solicitor, you ring them up for advice, but they're not advising you against what's written down. They're advising you what they think is the right procedure, and you're breaching your own contract. So be very careful of that. Is your process and outcome proportionate to the offence? So, you know, you've got to be very careful of this. You know, serious misconduct. It's very rare we actually just get rid of somebody for serious misconduct. And if you are going to get rid of somebody and dismiss them because of serious misconduct, you've got to have the policies and the proof there within your handbooks to show that you are able to do that. Have you followed a fair and reasonable procedure? And has that procedure been applied consistently? So do you have the authority to act? So we're looking at disciplinary action, a formal verbal warning, written warning, final written warning, dismissal. And you can see on there's only 3 really that are done by the manager, but dismissal should be done by the director and director alone. The process investigation. Now, it may be that people have the luxury of an HR department, and that's somebody that would do that and take over that. But lots of people that I deal with don't have the luxury of that. And even now, there's so much more to do. So the process for an investigation, if somebody's saying something's happened, we're not going to tolerate somebody's intolerable behaviour by keeping them there. We're going to investigate the facts, and we're going to investigate without any delay, because by delaying it, what we're doing is we're tolerating somebody's intolerable behaviour. So investigate even if the employee seems guilty. Investigate thoroughly to ensure that you get the true facts in place and that the substance of the allegations are very clear. And remember, there's no statutory right to be accompanied at this stage, but consider whether you would want to allow employees at this stage if they request it. You might look at age there, apprenticeships, age. It might be a language barrier. It might be somebody who's not very confident. I don't mind a witness being at this stage because I think it just gives some support. And the last thing at this moment in time anyway that I want to do, and the last thing I'm thinking about, is dismissal. Here I'm actually just concentrating purely on the facts and the investigation and to get the right picture in front of me. No formal disciplinary action should be considered at this investigation stage. Try and make sure that the investigator manager is different, and if you can, more junior than the manager who will be hearing the subsequent disciplinary hearing. You've got, I keep drumming into you this ACAS code. It encourages informal resolution. Consider whether you are proceeding in a formal or informal manner, as I explained to you before. But you need to keep notes, even if you're dealing in an informal manner, and make employees aware that if further instances, misconduct, poor performance occur, you may take it down the formal route. And this might involve, as I said, that letter of concern. So again, we're still with the investigation here. You might consider suspension, but remember, if there's two parties involved and both are as guilty as each other, don't just suspend one without the other, suspend them both. We've got to have consistency here. Any suspension should be kept as brief as possible, both for the employee and employer, for suspension costs, because it is costly, and review the suspension regularly. The terms and reasons for the suspension should be communicated verbally to the employee at the time of the suspension and then confirmed in writing as soon as possible. Normally, unless the contract states otherwise, during any suspension, an employee should continue to receive full pay and their benefits. So use of company car, gym, etc. Like we've got a gym available to us, seriously. Inform employee who their point of contact is during the suspension period, and that way there's no surprises. And you know, you've got to remember, somebody here is worried about their job and their future, and it's going to be life-changing for them. It's going to affect them, so they need a point of contact to know how it's going on. And just because an employee is suspended doesn't mean to say that disciplinary action will be taken, and you need to reassure the employee of this and let them know that any matter has not been predetermined. So the invitation to a disciplinary hearing, you should ensure that sufficient notice is given for attending the hearing. An invitation letter has been sent in good time to the employee. Provide documents and information that will be used in the hearing and request confirmation of attendance. So at the hearing, there are required elements that you should do, and you should be really making sure that you're putting them at ease, allowing them to talk, not talking over them. But what you should be doing is formalising this. It's not really relaxed. This is a formal hearing. So an introduction of names and roles, explain the structure, the status of the meeting, representation rights, agree note-taking procedure. You're then going to outline the evidence and produce witness statements as necessary, and you're going to allow the employee to challenge evidence to state their case. You can also adjourn when necessary and ensure you do so to consider your final decision. And remember, I know these slides, there's a lot of information in them. I have to do it like this because we're talking about a formal procedure here. I need you to get it right. So the process, the disciplinary, inform the employee in writing of allegations and invite to meeting. Make sure that you have written and set out with sufficient information all the allegations and possible level of disciplinary sanction. This will enable the employee to prepare their side and get ready for this because, as I said, it's going to affect them. You need to include documentation and evidence that will be used or relied on in the meeting, and it gives the employee a chance to challenge that. Inform the employee that they have the right to be accompanied, fellow employee, trade union representative. And remember here the new change to the ACAS code on fellow employee. They can have somebody else from a different site. Meetings should be convened at a reasonable time and place. Meetings should be within the normal working hours. Provide reasonable notice that so that you are given the employee time to prepare. And if the matter is sensitive, excuse me, or of a confidential nature, it might be advisable to hold the meeting elsewhere because people look, don't they? They want to know what's going on. And if an employee asks for postponement, consider this request. Excuse me. So now you're holding this disciplinary hearing just as you would before. Set the scene. Okay, make people relaxed. Check that the employee is comfortable with the arrangements that have been made. Make a note of this because this is a defence to you. They've said yes and that they've received all the right documentation. Explain the charges against the employee and explain and go through the evidence. Give the employee a chance to ask any questions about it, and then also to present their evidence and yours and call relevant witnesses. Prior to closing the hearing, you need to check with the employee whether they have anything further they would like to add or say in their defence. Summarise the meeting and then adjourn to consider any follow-up or decision. If possible, at this point, ask the employee to read and sign the notes of the meeting, to agree to accuracy or to provide comments. So the tips I would give you for the disciplinary hearing: approach the hearing bearing in mind that you want to avoid an employment tribunal hearing resulting from this process. You are the chair. Don't let somebody manage you or control you. It's your meeting. You must let them, the employee, present their response to the alleged matters concerned. Don't rush through it. Have a note taker because it makes you concentrate and listen properly. Both parties should ultimately agree the notes of the disciplinary hearing. The focus of the disciplinary hearing should be on the matter of concern and not other stuff. Be aware of tactics. Employee may attempt to divert and deflect the hearing away from the reason for the hearing, quite often by putting a grievance in. You're in control. So the decision outcome don't appear to make or advise in the disciplinary hearing, as this will appear as no consideration or reflection has been taken whilst the to what the employee has stated in the disciplinary hearing. Don't type up the letter in preparation. Advise of the outcome decision in person writing. Issue appropriate level of warning or dismissal, but it should be in line with your own disciplinary procedures and what you've got written down. Provide the right of appeal against any level of warning and dismissal. And normally and ideally, a different individual should hold each stage of a disciplinary situation. So what we have somebody different for the investigation disciplinary hearing and then somebody more senior for the appeal. So what is the role of the worker companion or union representative? They're there to represent the employee and support, to ensure that fairness is followed, ensure employees state their case fully. They'll have more insight because they've spoken to the employee and they'll know if the employee has not mentioned something. They're there to take notes for the employee, ask questions and suggest follow-up actions. So you may keep a list of that and make notes and give that to whoever is the role, who is going to be the work companion. So now we've reached the appeal. Somebody's not happy about what you've done. And now what happens is you're going to inform the employee in writing of decision and offer of appeal. And you're going to do this because this is your evidence. You're going to keep a copy of this. Any decision should only be made after the disciplinary hearing has ended. And you can inform the employee verbally of your decision after a short adjournment. You have to inform the employee in writing of any decision as soon as possible after the hearing. The decision letter must set out sufficient details of any reasons for any decision to impose formal disciplinary sanctions. Remember, the most important thing here is the decision letter must contain the right of this appeal. The deadline date for appeal to be submitted and recommended by ACAS is this 5 working days. And make sure it is the 5 working days. People go, oh yes, and then they forget that it was weekends. They didn't send out the Friday, include the weekend and whatever. You know, it's 5 actual working days. If employee appeals, send a written invitation to appeal and attend the appeal hearing. Don't be offended because employees have the right to appeal. You are actually making a decision that they may feel is wrong. So they should let you know the grounds for their appeal in writing when they do actually appeal. You can ask them to set out full details of the grounds prior to the appeal hearing to give you a chance to consider that as well. And remember, this appeal hearing should be held by a manager who has not previously been involved in the process. I would try and get a more senior person than the person who made the original decision, and then send the employee a written invite to attend the hearing. Written invite should set out the proposed arrangements for the appeal hearing, contain the identity of the appeal manager, inform the employee they have the right to be accompanied, but also you should hold this meeting in a reasonable time, place and during working hours as you would have done before, and consider any requests for postponement. So now we're at the appeal. We're holding the appeal hearing. The appeal manager should have had access to the evidence compiled during all the previous procedures. So that's the investigation initial disciplinary stage. The appeal manager should not confirm with the initial decision maker prior to the appeal. And this is really crucial, this. It is possible that any procedural defects in initial disciplinary hearing may be corrected on appeal. So if the appeal hearing is sufficiently comprehensive, that might happen. Set the scene again by asking, is employee comfortable, had all the documents, and happy with all the arrangements that have been made? Listen and give employee a reasonable opportunity to present their grounds for appeal. Again, it's the same as before, calling relevant witnesses, looking at evidence, and prior to closing the meeting, check if the employee has anything further to add. And this is a statement that we would use in tribunal to prove that they've had the chance to appeal. We actually asked them if there was anything further they wanted to add to the situation. You need to sum up the meeting, adjourn to consider any follow-up action or decision, and if possible, ask the employee to read and sign the note to the appeal hearing as accurate, and also, if want, to provide comments. So informing the employee of a final decision in writing, decision made after the appeal hearing. You may inform them verbally. It's after a short adjournment. Employees should be informed in writing of the result, even if you have informed them verbally of the appeal hearing decision, as soon as you can after the appeal process has ended. In cases where there is a dismissal and the dismissal has been overturned, consider the level of support in facilitating the return to work and integration within the workplace, especially if they've been off for a while. If the employee is not successful in their appeal, the letter must contain the decision and set out the reasons why the appeal was not upheld. So 10 top hints and tips for dismissing and not ending up at an employment tribunal. Have a disciplinary procedure in place. Make sure your employees are aware of the procedure and misconduct. Be careful of assumption. And if you do that, but you've got to look at the facts. You're going to end up with a tribunal. Let the facts speak for themselves. Aim to be fair, consistent and reasonable in the application of the disciplinary procedure. Follow your own processes. Use balanced and neutral language. Remain calm and in control. Don't prejudge or preconsider, and consider the bigger picture as well. So I hope that it give you a short snappy sort of look into disciplinaries, appeals, and really some things that you should have in place really at the very beginning to prevent this happening in the first place. If you are a Peninsula client and you have any issues with your staff, or you want letters writing, application forms, remember that's part of our service. You don't get charged per letter or advice that we give. It's all part of our product that you've purchased on a monthly basis, a monthly payment. And what that means is that it doesn't matter how many phone calls or how many letters we write or how much documentation we provide. In our eyes, this is preventative, because our long-term goal is to stop you having a tribunal. I don't care how little the complaint is, you ring us up. Remember the health and safety service and the employee assistance service as well, where we offer a service to protect your staff's health basically. And remember my name. My name's Amanda Chadwick. I work for Peninsula Business Services. I'm a senior speaker there. I've been a speaker for over 20 years. My specialist subjects are employment law, health and safety, and employee wellbeing. This today was a formal webinar. Normally we have a little bit of a chat and a laugh, don't we? But today it is disciplinaries we're talking about. There's no beating around the bush. You've got to do it right. If you do it wrong, you'll end up in a tribunal. Remember that. And it's very, very costly. If you want to email me, my email is amanda@peninsula-uk.com, and I hope I help you soon. Thank you very much for your time, and have a lovely afternoon. And it's goodbye from me.